The tort of deceit is a type of legal injury that occurs when a person intentionally and knowingly deceives another person into an action that damages them. Specifically, deceit requires that the tortfeasor deceit dates in its modern development from Passley v. Freeman. Here the defendant said that a third party was creditworthy to the claimant, knowing he was broke. The claimant loaned the third party money and lost it. He sued the defendant successfully. The leading case in English law is Derry v. Peake, which was decided before the development of the law on negligent misstatement. In Hedley Byrne & Co. Limited v. Heller and Partners Limited, it was decided that people who make statements which they ought to have known were untrue because they were negligent can in some circumstances, to restricted groups of claimants, be liable to make compensation for any loss flowing. Despite the decision in Derry v. Peake, this falls under the so-called voluntary assumption of responsibility test. In Bradford Equitable B.S. v. Borders, it was held that in addition the maker of the statement must have intended for the claimant to have relied upon the statement. Negligence and deceit differ with respect to remoteness of damages. In deceit, the defendant is liable for all losses flowing directly from the tort, whether they were foreseeable or not. In Doyle v. Albee Limited, Lord Denning Mr. remarked, "It does not lie in the mouth of the fraudulent person to say that they could not reasonably have been foreseen. So where there is a sudden downturn in the property market, a person guilty of deceitful misrepresentation is liable for all the claimant's losses, even if they have been increased by such an unanticipated event. This is subject to a duty to mitigate the potential losses. Contributory negligence is no defense in an action for deceit. However, proving deceit is far more difficult than proving negligence, because of the requirement for intention.